Welcome back to the morning show here on Rise News and the conversation. We're switching things over, and trust me, boy, it's going to be an exciting morning this morning. Let's just go straight to it now. Nigerian Supreme Court, led by Justice Tope Akinyode and 6 other justices, have struck out the appeal of the presidential candidate of the People's Democratic Party, Atiku Abubakar, challenging the ruling of the Presidential Election Petition Tribunal, which in September upheld Muhammadu Buhari as the winner of the February 2019 presidential election. Shaita?
The 7-man Supreme Court panel, led by the Chief Justice of Nigeria, dismissed Atiku's petition for lacking in merit.
Indeed. And joining us now is Tope Akinyode, a legal practitioner, to discuss the Supreme Court's final pronouncement on the 2019 presidential election dispute. But before we get started, let us see this report from our senior news correspondent in Abuja, Chima Nwankwo.
The arguments were familiar. Lead counsel to the People's Democratic Party, Dr. Livy Uzuku, argued that the Independent National Electoral Commission indeed had a server and challenged INEC to show where they stored their smart card and PVC data. Counsel to the Independent National Electoral Commission, Yunus Usman, said Atiku Abubakar and the PDP failed woefully to prove that they won the majority of lawful votes cast at the February 2019 election. He pointed out that out of 119 polling units, they called only 5 polling agents as witnesses to prove that there had been voting malpractices across the country. Yunus urged the court to strike out the appeal and award INEC substantial costs. He was supported by counsel to Muhammadu Buhari, Wale Olanikpekun, who urged the appellants to stop being dramatic. He said Muhammadu Buhari had complied with the provisions of the Constitution, which do not require him to present a physical certificate. Just like INEC lawyer Yunus Usman, he asked the court to dismiss the appeal. The counsel to the APC, Lateef Fagbemi, said that Section 131 of the Constitution spelled out the qualifications a presidential candidate ought to have, and that Section 318 states clearly what constitutes an ordinary level certificate. He said the evidence of witnesses called by Atiku and the PDP was unreliable and full of loopholes. Lateef Fagbemi also asked the court to dismiss the appeal. The Chief Justice, Tanko Ibrahim, announced that, having examined the evidence for 2 weeks, the Supreme Court decided to dismiss the application.
But let me say this, that unless something drastically is done to electoral jurisprudence in this country, there will be a problem. We want to appreciate and then commend the Supreme Court for rising up to the occasion. I think that's the way it should be. And the judiciary has done well. For us as counsel, we've done our best, and counsel for all the parties have tried.
This server, INEC never said there had no server. They said INEC had a particular server, www.factsdon'tlienigeria.com. We say INEC does not have that type of server, and they said it is through that server that results were transmitted.
The chapter, paragraphs and lines having to do with 2019 election, especially the presidential aspect, has been laid to rest.
Justice Ibrahim said that the reason for the dismissal will be announced at a later date. Chima Nwankwo, Arise News.
Well, reports there by Chima yesterday in court. And Tope Akinyode, a legal practitioner, joins us now. Thank you so much for joining us. Just to start off, was there anything unusual for you at yesterday's hearing and decision of the Supreme Court? Is it unusual to have such an appeal, dismissed on the first hearing, and then the details, we don't even have the details yet, so everything else is speculation at this point, isn't it?
Well, in attending to your question, we'll have to look into the provisions of the law.
Okay.
And while doing that, we have to also bear in mind that the court which gave the judgment yesterday is the Supreme Court. That's the apex court of the land. And, when the Supreme Court gives a judgment, it's final.
Yeah.
However, going to your question, and I guess you are trying to say that, well, the Supreme Court just said, these are our position. We'll give you details later. The law allows it, actually.
Okay.
We check the Electoral Act, Section 135. In fact, Subsection A, B, C, D gives specific provisions about courtroom practice, tribunal, in electoral matters. But Subsection D says that, well, the court has liberty to say, this is my judgment at the moment, this later or at a later moment, I will give the reasons. So somehow, it isn't expected because it isn't outside of the confines of the law. But, you know, the worry for me as a person is that consistently, I mean, since 1999 till now, we have had to hinge the electoral or democratic destiny of this country via the ballot on the courts. I mean, that's not...
With the exception of 2015.
With the exception of 2015, you are very correct. Now, basically, that's not the functions of the court. And anytime we have to wait on the court, the Supreme Court or any other court at that, to decide the outcome of an election, it exposes the institution for which, or the institution that's meant to primarily handle elections, which is INEC. I mean, there's no gainsaying we are running at loss, electoral-wise, in Nigeria as per management. We spend so much of money, logistics, personnel, to get almost no result. I mean, if the courts have to perform the functions of INEC, there's a big problem. That's my worry.
But a lot of people will argue with you and saying, it just shows the robustness and the beauty of democracy and the fact that the court steps in. I'll give you a clear instance. You had 2,000 elections in America. They went to the Supreme Court. The Supreme Court ordered a recount. They recounted. And it went back and forth before the election was called. So if you feel aggrieved, why can't you go to the court? Even in the fairest of systems, you still have people go to court.
I agree with you perfectly. You know, but you have to understand this. See, the mindset of the court in electoral tribunal matters is a little bit strict. You would not expect that someone who won through popular votes, the mandate of the people, will get deprived of that mandate for no reasons. So the court have a mindset to be very guided, not to usurp the power, the democratic power of the people. I agree with you that exceptional circumstances...
But that depends on the systems. I mean, because if you say that in America, for example, we're not comparing with America.
No,
you know, you can win the election. I mean, like this last American election, Hillary Clinton won the popular vote, but she didn't win the electoral college vote. So it depends on the system. So but the fact that you won the popular vote doesn't mean that you can't still be, you know, pushed out. I mean, when you go back to the case of 1979, Awolowo versus Shagari and the Supreme Court, the interpretation of 2/3, that's another clear question. I mean, if it had ticked the balance, it's about the fact that Shagari won the popular vote, he would have been called again.
Definitely. No, I agree with you, like I said. But again, we must come to the reality that election petitions aren't meant to be the classic or running functions of the courts. It has a toll on the system because you have so many cases the courts have to decide. Election petitions must come first because of the time limits. And then you waste the time of the court, you waste the time of the judicial system just because you want to raise frivolities. I'm saying that the body that is meant to conduct elections should be up and doing to the extent that it will conduct free, fair, and credible elections such that anybody who loses in an election will be able to say, yes, I lost. I mean, there's nothing wrong.
How can the body conduct free and fair election when the president refused or did not, I don't want to use the word refused, did not sign the new electoral bill into law? Well, how can you conduct free and fair elections when the Uwais report is still gathering dust? There. So how can you conduct?
Again, you come to the unfortunate reality, you know, that we have in the country. See, people take decisions at the end of affair because of selfish interest. Absolutely insensitive to the yearnings of the people. The electoral system, the electoral laws, are long overdue for a total overhaul. And there's no gainsaying about it. Specifics of the laws should have been amended to to be in tandem with the reality of the country. But you see, the president, in declining the bill, said elections are near, elections are around the corner, that it will throw up some imbalance that he doesn't want to attend to it. Why? Because he feels he will be privileged in this system, which all of us are clamoring against. So it goes to show the kind of leadership we have in the country, how we run our democratic system painfully.
I have two questions for you. First off, you have, like Adesuwa rightfully mentioned, that the Court of Appeal throughout the case saying it lacked merit and that the decisions, how they came to that decision, would be stated later. The Supreme Court said, yeah. So is there a timeline? Is there a time frame? How long do we have to wait to find out what those decisions are? Because Nigerians do have that tendency to move on to the next thing. However, it's still very important to know why it was thrown out. Is there a timeline for this? And also, Atiku's response to this is that the Nigerian judiciary system has been sabotaged and undermined. What is your take on the fate of the judicial system as it stands now?
All right, okay. Now, this is the issue. Like I said, the law allows that the court might reserve the reasons for the judgment. I agree with you that we need the reasons because it will form parts, because obviously it is turning into law itself. It's forming judicial precedent and somehow that's law. No, so we need it for that purpose. However, the court hasn't given a date yet, but we are satisfied with the reality that there's no way the court will not give its reasons. Now, if you are going to be talking about the independence of the judiciary, whether the judiciary has been sabotaged, I mean, those are political statements which I may not want to dabble into. As a lawyer, I would prefer to deal with the merits of this issue. And from what we have seen from the appellate court, the appeal court, to the Supreme Court, I'm not too shocked or surprised that the matter came out the way it came, the result we have, because, you are talking about courtroom practice, especially tribunal, petitions, electoral petitions, you are talking about evidence. The major pieces of evidence of these other people, the PDP, kept holding no water upon trial. So, as a lawyer, I can't be emotional about the matter. The reality is that, there is so much of public complaint against the election. The European Union and all of the international community.
I want to test that with you of holding water, no water at the trial. We'll come back after this quick break. We'll come back and talk through that.
All right, okay.
Right, welcome back. Still a morning show here on Rise News, and we're talking to Tope Akinyode, legal practitioner. We're discussing the Supreme Court's final pronouncement on the 2019 elections. There are many points I wanted to hold you on, and I just want to test some. Number one, the case of the sworn affidavit. The fact that if somebody doesn't have a certificate and he swears an affidavit, are you saying variably that holds water?
Okay.
That is okay. Like, take, for instance, I lose my certificate and I said, I went to Oxford or I went to Cambridge, and I did PPE, and I just have an affidavit to that effect. Does it hold water?
All right. Now, in the context of this case, the issue of affidavit arose in the first instance because the petitioners are saying Muhammadu Buhari does not have a school leaving certificate. Now, the law is the provision of the Constitution, Section 131, Subsection D of the Constitution, does not even stipulate a need for a certificate. Let us get that established first. No matter how they want to raise or the dust or anything about the issue, the law does not specifically say have a certificate. Now, having said that, the truth of the matter is this: an affidavit in itself holds the weight of law. Yes, they may have facts to say that the president told lies in the affidavit. Good. They, as lawyers, know what to do next. Proceed to court and ensure that the court pronounced perjury against the person involved. And immediately you can have that. The affidavit becomes useless. Otherwise, you cannot impeach it.
Well, like we said, we're still waiting for the reasons to be given. We don't even know if this was a unanimous judgment by the 7-man panel.
The CJN said it's a unanimous.
It was a unanimous. Okay,
yes.
Great. But given the background of where this is coming from, the petitions tribunal, that was a unanimous judgment and saying that the petitioners failed to prove their case and there was not enough to alter the outcome of the elections. Are you as shocked as the PDP at the decision by the Supreme Court? And I want to ask you, because you are the lawyer here, the composition of the panel, which raised some dust by the PDP, is it customary for the petitioners to know the composition of that panel before date? And how is this panel even set up?
You see, I don't know any such provision of the law that gives liberty to the petitioners to have a right of say in the composition of the tribunal. You see, politics is politics, law is law. Again, well, someone is this, someone is that, we don't want him on the panel. The law does not give liberty to the petitioner to make such things. I'm not entirely justifying the system, don't get me wrong. Issues like this bring up an opportunity for us to really address salient issues arising, to really consider that, are we prepared to continue this path or not? So it is not, I'm not saying, I'm not being judgmental, I'm not passing a moral judgment to say it is good or bad. I'm just saying, well, basically, the composition of the panel is not such, is at the discretion of the CJN, and he exercises his discretion. You can't argue that. Now, but again, I can't be shocked. I can't be shocked as a lawyer because we deal with evidence. And, for example, the PDP, one of their major cases was there's a server.
The INEC server.
The INEC server. And, you know, so many people had faith, people with the legal minds following the case had faith, yeah, that, oh, really, there was a server and all of this. But we got to court, they got to court, and we discovered during trial that, really, you can't even substantiate that there's a server. I mean, you are trying to justify the provision of a server by hearsay.
A website called Facts Don't Lie.
I mean, Facts Don't Lie, one website that anybody can put up. Even the witness in court testified that, yes, anybody can foray into the website, put up anything there, or even shut it down.
And the witness didn't have prior good knowledge.
I mean, no knowledge about what is so you discover that really, I mean, it's all, I mean, these are, I don't know it. I mean, nothing really. Because, yes, I agree with you that INEC might have played pranks on Nigeria because at the time it said, oh, we are going to use server. Later time, we didn't hear information about the server again until they came to court and they were vehemently declining that they even had the server. In fact, they were almost saying that they didn't even issue a statement about a server before. You know, so, I mean, it goes to how poorly managed the administration of electoral practices are in Nigeria. But that, again, doesn't mean that there's good evidence to establish that there's a server. I mean, so if you are relying on, and it is upon that server you are saying you have results, that your other results, I mean, and you can't even substantiate that, I mean, you can't build something or nothing and expect it to stand. It's the case we had at the court, and it's a big drama we saw, you know, throughout the entire proceedings.
Would you say it was a waste of time?
Well, I would not want to prejudice.
The APC had said, that this was a complete waste of time. The PDP
parties can say what they like. As a lawyer, I'm not going to prejudice the right of any party to approach the law court for the determination of its rights. But again, I believe strongly that the law should be revisited to really bring up a working system, electoral system, like I said, and I must insist on this, and a working electoral system where you will not have to, drop all electoral petitions on courts. I mean, if 4 of us here on this table contest an election, probably an open ballot, you are not going to likely say that, oh, really, you are not going to likely contest the result. Why? Because the system is transparent. We are saying that we are running a system that isn't transparent. The international community faulted this election as one of the worst ever, or the worst ever. Since 1999 now.
So, but
killing people of about, the report, the statistic we have is about 53 to 55 people were dead in the process.
And over 700 cases, across board.
Across board.
But let's talk about, a lot of people will say, we had a chance to have a silver bullet with electronic voting that we botched, that we said we are not ready for. Countries as small as Somalia are doing it. Why are we not doing it?
What?
Somaliland, I wanted to say.
All right, okay.
Somaliland is doing it.
I agree with you that we are not getting it right yet, democratically in this country. It's truth. I mean, even the top parties who contested the election, the two parties, nothing to offer from those guys. So basically, I must say that we are not yet there, democratically, politically, the processes, the enlightenment, we still need so much of enlightenment for the mass, for the people. And, the ruling class have been using poverty and hunger as weapon, against mass education of the people. So basically, we need to go back to the drawing board to say how to really look at how we can make our democracy work and function well. And then we can now begin to make mature, reasonable, wise decisions. So, yes, we are not getting it right yet in the process, in the governance process in the country.
Looking at, we're talking about the electoral reforms, and even at the 2019 presidential elections, we realized that we had the highest number of political parties take part in the elections, and that in itself is one of the problems that we face because it's not e-voting. The members of INEC find the process very rigorous, and it's hard to backtrack and count the numbers. There have been occasions where they've actually said that sometimes they don't even count it, they just write whatever figures they feel comfortable with. What laws can be put in place to kind of minimize these political parties that contest, or is it something that can be open to anybody?
Well, the fears may be correct that registration of political parties are on the rise. We must also bear in mind that really we don't want to turn Nigeria into a two-party system. To make it a party between the APC and the PDP, which clearly there's no difference between. But again, the commission is at the best position to advise us on what they have seen on the field, on the challenges they have seen, on their measurements, growth measurements, and to provide, to give us suggestions, to say, okay, but we don't have people do that to us here. We don't have people say, after the 2019 general elections, these are our observations. These are the things we found out. These are the challenges we have met in the field, and these are the laws we think should be able to aid us. We cannot assume for them that they are overwhelmed. What are they getting paid for? We get so much allocated to them through our budgetary process. I cannot excuse their failure. For whatever reason, let them come out to tell us these are the things, and then we cannot raise a discussion around that.
All right, we'll keep our eyes on the staggered elections coming up in Bayelsa and Kogi states because INEC is promising so much. They've had so many reviews after the general elections, and we hope to see implementation and minimal repetition of those mistakes. Thank you so much, Mr. Akinyode, for coming on the show today. And that brings us to the end of the show. I am Adesua Omorwan.
I'm Rafal Yuseni. And
I'm Sheito Atigari. Thank you for watching from my entire team here in Lagos. Enjoy the rest of your morning and, of course, the rest of your day. Goodbye.